day. Welcome to Lawyer Up by NDV Law. This is Attorney Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. Selling property should not be a complex matter. Although it is advisable to secure the services of a lawyer to draft the contract of sale, there are templates that are readily downloadable in the internet. But of course, care must be taken in using these templates since they're not customized and may not be entirely accurate or applicable to the parties at hand. So, in this video, I will teach you or give you a simple guide to contracts of sale for those who wish to have a general overview on what these contracts should contain. Well, first, you have to determine the type of contract that you wish to enter into. It will be a deed of absolute sale if full payment is made and there is immediate transfer of ownership. However, it will be considered as a deed of conditional sale if payment will be made in installments or there is some kind of condition before transfer of full ownership. Second, you have to ensure that there are proper parties. Say for the seller, if married, then the spouse must signify his or her consent. Otherwise, the sale is void. Under the Philippine Family Code, if the spouse sold the property without the consent and knowledge of the other spouse, then the sale is void. However, the transaction shall be considered as a continuing offer and may be perfected upon acceptance of the other spouse. But on the other hand, if the spouse sold the community property without the knowledge but without the consent, with the knowledge but without the consent of the other, the contract is merely annullable. The other spouse has 5 years from the date of the contract to go to court and seek the annulment of the contract. Let's move on to the buyer. There is no need for spousal consent, but I do suggest that you include your spouse, well, just to be sure. It may form part of the absolute community of property or conjugal partnership of gains anyway. Next, you have to ensure that all parties are of legal age, meaning they must be 18 years of age and above, or if not, a guardian must sign for them, of sound mind, not declared insane, and not laboring under any restrictions such as under guardianship and the like. There is also a need to state the names, the addresses, the civil status, and the tax identification number of the parties. Third, you must specify the details of the property, such as the address, the TCT number, and the technical description and boundaries, because this will govern the scope of your ownership. Well, fourth and last, you must state clearly the consideration and other terms agreed upon, such as first, well, of course, you have to state the price. This will actually be used by the Bureau of Internal Revenue or the BIR as a basis to assess capital gains tax. If the zonal value is higher, then the BIR will use the higher value. Please note that the capital gains tax is 6% of the value of the property. Thus, you have to ensure that the seller will be shouldering this. Although in some instances, the buyer can actually agree to pay for the capital gains tax. Also bear in mind the transfer taxes must be paid to the local government unit concerned and the Register of Deeds. Well, this is usually borne by the buyer. If the sale is in installment, you must state the amount of down payment and the period of installment and amount for each amortization. Oftentimes, as a usual practice in the Philippines, post-dated checks or PDCs, as we call them, are usually given by the buyer. So that's how simple it is to draft a contract of sale. But if you want something that reflects your intentions, you are free to contact a lawyer of your choice. Well, if this video has been helpful, kindly subscribe to our YouTube channel by clicking on the subscribe button. You can also visit our website, ndvlaw.com, to learn more about legal matters in the Philippines. Again, this is Atty. Nikki de Vega, Managing Partner of Nicolas and de Vega Law Offices. And thank you for watching Lawyer Up by NDV Law.